Defenses. Common form defenses. Slander, paragraph 1 of the particulars of claim, that is the prefatory arguments, is admitted. It is denied that the defendant spoken published the words set out in paragraph 2 of the particulars of claim. It is admitted that the defendant spoken published the words set out in paragraph 2 of the particulars of claim to the persons identified therein, but denied that he spoke and published them of and concerning the claimant, or of or concerning him in the way of his profession or in relation to his conduct therein. The said words do not and are not capable of being understood to refer to the claimant. The said words do not and were not understood to bear the meanings alleged in paragraph 2 of the particulars of claim or any defamatory meaning. The said words were not calculated to disparage a claimant in his profession or office, trade, calling, or business, as alleged in paragraph 3 of the particulars of claim, or at all. It is denied that the claimant sustained the loss and damage alleged in paragraph 4 of the particulars of claim, or any loss or damage by reason of the publication of words complained of herein. Save that no admissions are to made as to the circulation or readership of the said newspaper, paragraph 1 of the particulars of claim is admitted. The defendant denies that he wrote, printed, or published, or caused to be printed or published the words set out in paragraph 2 of the particulars of claim, or any of them. It is admitted that the said words referred or were understood to refer to the claimant. It is denied that the said words bore or were understood to bear or were capable of bearing the meaning set out in paragraph 4 of the particulars of claim, or any defamatory meaning. Save that the defendant does not admit the word in paragraphs 1 and 2 of the particulars of claim are admitted. It is admitted that on pages 6 and 7 of the Sunday Correspondent for May 2008, the defendant published an article which included the words pleaded in paragraph 3 of the particulars of claim. The said words formed part of a much longer article, to the whole of which the defendant will refer for the context and true meaning of the words complained of. It is denied that in their natural and ordinary meaning, the said words in their proper context bore or were capable of bearing the meanings, or either of them pleaded in paragraph 4 of the particulars of claim. If and insofar as the said words in their natural and ordinary meaning bore and were understood to bear the meaning set out below, they were true in substance and in fact. That the claimant has been guilty of a reprehensible lack of parental responsibility by abandoning the child he had by his mistress. That the claimant is a hypocrite for making public pronouncements which are not matched by his own private behavior. The defendant is required clearly to identify the meaning of the words which he seeks to justify. For pleading requirements when justifying, see paragraph 2.2 of the practice direction, CPR point 53 and paras 29.5 to 29.10 above for explanations of repetition and conduct, rules and the professional obligations placed on a pleader. Set out all relevant facts and matters which support the plea that the words are true in substance and in fact. The claimant has been a member since 1984. As pleaded in paragraph 1 of the particulars of claim between May 2002 and April 2007, he served in the government as an Undersecretary of State for. In that capacity, he made a number of speeches in Parliament and in public, in which he espoused the cause of back the basics of social policy, which called for a return by society to traditional family values and placed a strong emphasis on parental responsibility. The claimant published a book containing autobiographical memoirs entitled Personal Reflections in or About Date. In the said book, there are a number of passages in which the claimant articulated his conviction that the root cause of various forms of social malaise was the dereliction by parents of their duties towards their children. Parents must be accountable to society. The defendant will refer to and rely upon all these passages at trial, but for present purposes simply refers to the page, paragraph number of the relevant extracts. At a press conference held on April 7, 2007, the claimant announced that he had had a sexual relationship with his former employee, a researcher named Miss Jan Smith, now Mrs. Brown, and that on June 7, 2004, she had given birth to a son, John, of whom he was the father, notwithstanding, and in flat contradiction of his previously adopted stance. At a further press conference on April 15, 2008, the claimant stated that he intended neither to take an active role in the upbringing of his son, nor to make any financial provision for him. The purported ground for this conduct was that he did not wish to interfere in the relationship of Mrs. Brown with her husband, who were happy to treat the child as their own. Further, alternatively, insofar as the said words made or contain the following comment or expression of opinion, namely that the claimant had behaved in a callous, hypocritical, and reprehensible manner towards Mrs. Brown and his son, the defendant contends that the words constituted fair comment on a matter of public interest, namely the propriety or otherwise of the conduct of a member of the government whose private behavior towards his own family stood in stark contrast to his public pronouncements on the issue at a time when he had direct responsibility for governmental policy on issues relating to social security. The defendant repeats paragraphs 4.1 to 4 above. Further, or alternatively, insofar as the words contain the comment or expression of opinion set out in paragraph 5 above, they were comment upon a matter of public interest upon the following facts which were stated to have been found proved in the judgment of Mr. Justice Just, given in open court on May 8, 2007, in wardship proceedings in the Family Division of the High Court of Justice in London, which related to the claimant's unfair and accurate report, which was published on page 5 of the same issue of the said newspaper. In his judgment dated May 8, 2007, Mr. Justice found that the defendant will rely, if necessary, upon the provisions of Section 5 and/or 6 of the Defamation Act 1952. No admissions are made in respect of paragraph 5 of the particulars of claim. If the claimant is entitled to any award of general damages which is denied, it is denied that the claimant is entitled to an award of related damages run by reason of the facts and matters alleged in paragraph 6 of the particulars of claim or otherwise. The defendant will rely upon the following in answer to the matters alleged in paragraph 6 of the particulars of claim. It is untrue that the defendant prepared and published the article without making any attempt to verify the facts, or the claimant to afford him any opportunity to comment on the proposed publication. On separate occasions, on Friday, May 1st, 2000, Peterson, the defendant telephoned the claimant at his office in Libel to seek the claimant's comments on the publication. Mr. Peterson was informed by the claimant's secretary that he was not willing to discuss his personal life with the media. Further, even if those attempts had not been made, the alleged failure to contact the claimant would not have been a justified ground of criticism of the defendant. Because the claimant stated at the press conference held on that he was not prepared to discuss his private life. Further, in particular, the arrangements he had made for his son with Mrs. Brown with the media. If, which he denied, the claimant is entitled to any damages and mitigation of those damages, the defendant will rely upon the fact that the claimant has brought a claim and has received compensation for damages liable in respect of a publication in the Rockford Times newspaper of date of words to the same effect as those complained of in this section. By reason of the matters pleaded above, it is denied that the claimant is entitled to the injunctive relief he claims against the defendant in paragraph 5.7 of the particulars of claim. I believe that all the facts stated in this defense are true. Save that the defendant's was that the claimant was summarily dismissed from his employment with International Finances Incorporated, and in each case for gross misconduct, paragraph 1 of the particulars of claim is admitted. Save that no admissions are made as to the precise size of the circulation or the influence commanded by what's happening with finance, paragraphs 2 and 3 of the particulars of claim are admitted. It is admitted that the defendant published in the issue of the said journal for date the words set out in paragraph 4 of the particulars of claim. It is admitted that the words complained of, bore, and were understood to bear the meaning alleged in paragraph 5 of the particulars of claim. The words complained of consisted of a fair and accurate report of legal proceedings in public brought against the claimant, and accordingly were published on occasion of qualified privilege. In criminal proceedings which came on for trial at the Central Criminal Court, Old Bailey, London, on May 31st, the claimant was prosecuted 15 counts of theft contrary to Section 1 of the Theft Act 1968 in connection with the disposal of International Finances Incorporated's assets to a number of bank accounts held offshore in Bermuda in his name and/or in the name of shell companies incorporated by him. On June 25th, the claimant was convicted on 2 of the said counts of theft which related to the misappropriation by him of some £120,000 of his client's investments, and was sentenced to 2 years imprisonment, suspended for 2 years. To the extent that the words complained of referred to the said criminal proceedings against the claimant, namely the headline, paragraphs 1 to 12 and 20 to 23 of the article complained of, they constituted a fair and accurate report of the said proceedings which took place in public before a court in the United Kingdom. Accordingly, the said words are protected by qualified privilege under Section 15 of the Defamation Act 1996, being a statement within the meaning of Part 1, 2 of Schedule 1 thereto. Further, or alternatively, in the natural and ordinary meaning contended for by the claimant and admitted by the defendants in paragraph 4 above, the words complained of are true in substance and in fact. The defendant repeats paragraphs, right? Further, if and insofar as may be necessary, the defendants will rely in mitigation of damages on the following facts and matters. The claimant has at all material times borne a general bad reputation as a dishonest fraudster. In support of this allegation, the defendant will rely upon the conviction of the claimant referred to in paragraph 5.2 above, and upon Section 13 of the Civil Evidence Act 1968 in support of the contention that the said conviction of the claimant was conclusive evidence that he committed that offense. It is accordingly denied that the claimant has suffered the damage specified in paragraph 6 of the particulars of claim, or any damage by reason of the publication by the defendants of the words complained of, or the defendants are liable for any embarrassment or hurt to the claimant's feelings as to which no admissions are made. Further, by reason of foregoing, it is denied that claimant is entitled to the relief sought in paragraph 7 of the particulars of claim or any relief. I believe the defendant believes that the facts stated in this defense are true. If it is denied that the defendant continues to cause the words completely of in paragraph 1 of the particulars of claim to be published. Paragraphs 1, 2, and 3 of the particulars of claim are admitted. It is denied that the words complained of for or were understood to bear or are capable of bearing the meaning alleged in paragraph 4 of the particulars of claim. Insofar as the words complained of meant and were understood to mean that the claimant was under suspicion of committing the offense of tax evasion and had behaved in such a manner as to give rise to such suspicion, the defendant has duly made to the claimant an offer to make amends pursuant to Section 2 of the Defamation Act, which has not been withdrawn by the defendant and has not been accepted by the claimant. The defendant first received notice of the claimant's complaint hearing by letter from his solicitors dated as soon as practicable thereafter on having accepted the word complained of board a specific defamatory meaning set out herein, therefore the defendant made the claimant a qualified offer in accordance with sections 2.2 and 2.4 of the 1996 Act. The said offer has not been withdrawn by the defendant and is relied upon by the defendant pursuant to section 4.2 Defamation Act 1996 by a letter from the claimant's solicitors dated. It was indicated on behalf of the claimant that he did not accept the said offer. Further, alternatively, if and insofar as is necessary, the defendant to rely at trial on the facts and matters set out under paragraph 3 above in mitigation of damages. By reason of the foregoing, it is denied that the defendant is liable to compensate the claimant for any damage or hurt he may have suffered, as to which no admissions are made by reason of the words complained of as alleged in paragraph 5 of the particulars of claim, or at all. Paragraph 6 of the particulars of claim is denied. Said words were published on occasion of absolute privilege. The defendant is a barrister. Said words were spoken by the defendant in open court on date in the European Court. Proceedings brought against the government of the United Kingdom by AB for whom at all material times the defendant was acting. The said words were spoken by the defendant in his capacity as advocate for the said AB and in the course of said proceedings. Statements made by Officer of State in official report. The said words were written and published by the defendant in his capacity as Permanent Under Secretary of State in an official report made to the Minister of and was therefore absolutely privileged. An accurate report of proceedings in the public published contemporaneously pursuant to Defamation Act. The said words were absolutely privileged pursuant to Section 14 of the Defamation being a fair and accurate report of proceedings in public before the Central Criminal Court, Old Bailey, London, and published contemporaneously with those proceedings. Particulars of action on so-and-so date, AB went on trial for the offense of rape contrary to Section 1 of the Sexual Offences Act. On the same date, at the outset of the said trial, the trial judge, Mr. Justice John, made an order pursuant to Section 4.2 of the Contempt of Court Act 1981, postponing the publication of any report of the said proceedings until the proceedings were concluded or further order. No further order was made during the course of the said trial, and on so-and-so date, the claimant was convicted. The defendant published a report of the said proceedings in his newspaper the day after the said conviction of the claimant in the premises. Insofar as the said report is published as soon as practicable after publication was permitted, it was published contemporaneously and accordingly is protected by absolute privilege. Paragraphs 1 and 2 of the particulars of claim are admitted, save that it is admitted that on the afternoon of the claimant and the defendant attended a debate in the debating chamber of Rockford County Council, during which the defendant made a speech. Paragraph 3 of the particulars of claim is not admitted. The defendant denies that he spoke or otherwise published or caused to be published the words set out in paragraph 4 of the particulars of claim on the date alleged or at all. In support of this contention, the defendant will rely on the official transcript of the proceedings of said debate. Further, alternatively, if which is denied, said words were spoken and published by the defendant, it is denied that said words were calculated to disparage the claimant in his profession or his office, as alleged in paragraph 4 of the particulars of claim or at all. The defendant avers that the said words are not actionable without proof of special damages and none is alleged. Further, alternatively, if which is denied, the said words were published, they were published on an occasion of qualified privilege. All facts and laws should give rise to privilege in this case in the duty interest situation to the claimant's attack on the character of the defendant, to which the defendant was responding. In the course of the said debate on so-and-so date, as is recorded in the official transcript of the proceedings on page X line Y, at or about 3:15 p.m., the claimant interjected during the speech of Counsel John Smith and spoke and thereby published the following words of and concerning the defendant. Mr. D knows very well, although he continues to deny that he is up to his neck in the Holmes Forwards scandal. He has sold council house to the people living in his ward on the cheap as long as they pledge their continued support. In speaking these words, the claimant wrongfully and unjustly attacked the defendant as behaving improperly in the discharge of his duties as a counsel and falsely accused him of cynically and unscrupulously selling residential homes owned by the council to private purchasers below their market value to his own political advantage. In the circumstances, the defendant was under a duty and/or it was his proper and legitimate interest to communicate to those to whom he said allegations were published by the claimant his defense to those claims and the true facts as to the same and the motives of the claimant in making them. And all those who heard the words spoken by the defendant had a corresponding and legitimate interest in receiving such communication. It was further averred that the communication by the defendant was reasonable in all circumstances, its dissemination being no wider than the attack by the claimant, and no wider than was necessary in order to inform those interested. Further, alternatively, the said words do not and were not understood to bear the meaning alleged in paragraph 4 of the particulars of claim. Paragraph 6 and 7 of the particulars of claim are denied. In the premises, it is denied that the claimant is entitled to the relief claimed in the particulars of claim or any relief. Further, alternatively, the defendant will counterclaim herein and will seek to set off the same in extinction or diminution of the claimant's claim. So later, at some time, the claimant, having called a press conference held outside the town hall, substantially repeated the allegations he had previously made in the debating chamber set out in paragraph 6.1 above, and thereby spoke and published the following words: defamatory defendant calculated disparaging away of his office as a councillor. The said words in their natural and ordinary meaning meant and were understood to mean that the defendant has cynically and unscrupulously sold residential homes owned by the council to private purchasers below their market value to his own political advantage. Further, as the claimant knew and could and did foresee by calling a press conference and speaking the said words to report it from the local and or national press, and they were likely to be reported and repeated in the local and or national press. Alternatively, it was a natural and probable consequence of the publication of the words of said press conference would be rehearsed in the local and or national press. In the purpose, the defendant contends that the claimant is liable for the publication of the following passages from reports in the local and or national press which repeat the defamatory extent of the words complained of and should be taken into account in the assessment of general damages. By reason of the publication of the said words by the claimant, the defendant has suffered Injury to his reputation was can cause serious distress or injury to his feelings, unless restraint claim will further publish the said or similar words defamatory of the defendant. And the defendant promptly claims damages for slander and the injunction issuing the claim whether by himself, his servants, or agents otherwise from further publishing according to be published the said or any similar words defamatory of the defendant. The defense, libel, common law, and qualified privilege, responsible journalism. Paragraph 1 of the particulars of claim is admitted. It is averred that paragraph 2 is admitted. As to paragraph 3, it is admitted that the words complained of were published by the defendant. However, it is denied that the articles bore or were capable of bearing the meanings pleaded. The article was not concerned exclusively with the claimant but dealt with wider political issues. Without prejudice to the generality of the defendant's case on meaning, it is averred that the article did not allege that the claimant was guilty would call for an investigation into his and other people's conduct. The tone of the article was measured and responsible. The words complained of were reached on an occasion of qualified privilege. The article was about matters of public and general concern and interest set. It was justifiable to include the defamatory allegations in the article. The steps taken to publish the information were fair and reasonable. In or about the author first learned about the allegations being made about the claimant and others connected with the claimant and decided to conduct research into these matters. By the time the article came to be published, the writer had conducted extensive research into the subject matter, in particular set out all investigations undertaken by the journalists, such as interviews with individuals, attending conferences, reading books and articles. Information obtained by the journalists was of a high quality. In particular, upon receiving the information relied upon in the article, it was checked, considered, and when necessary, corroborated. Prior to publication, the defendant took reasonable steps to contact the claimant to put the allegations to him and obtain his response. It was published on, because the subject matter was one of current concern. The article, when published, contained the gist of the claimant's side of the story. Where the defendant's subjective belief is relevant, including assertion to that effect, together with the basis of that belief. In the circumstances, the defendant had a moral and social duty to publish the words complained of, and the public had a corresponding legitimate interest in receiving the information. Alternatively, in the circumstances, the publication to the world at large was in public interest. Save that it is admitted that the claimant is a company which carries on the business of the manufacture and supply of birdseed. Paragraph 1 of the particulars of claim is not admitted. Paragraph 2 of the particulars of claim is admitted. Save that the defendant makes no admissions in relation to whom its marketing brochure was published. Paragraph 3 of the particulars of claim is admitted. It is denied that said was false as alleged in paragraph 4 of the particulars of claim or at all, without limiting the generality of this denial in response to the particulars of falsity. Without under paragraph 4 of the particulars of claim, the defendant pleads as follows. The defendant denies that any publication of the words by the defendant complained of as to which no admissions are made, save as admitted in paragraph 3 with malicious as alleged in paragraph 5 of the particulars claimed regarding the particulars of malice set out thereunder. The defendant pleads as follows. Paragraph Paragraph 6 of the particulars of claim is denied. Alternatively, if the claimant alleges that he has sustained actual pecuniary loss by reason of publication of the falsehoods complained of, state with regard to the paragraph, if which is in the cause of any loss sustained by the publication complained of by the claimant, no admissions are made as to the quantum of such damages. Paragraph 1 is admitted, save that no admissions are made as to the extent of what publication or circulation. Paragraph 2 is admitted. It is admitted that the defendant published the information set out in paragraph 3, save that it is denied that the defendant published information that could be understood to mean that the claimant was from Mrs. X's child. It is denied as pleaded in paragraph 4 that the defendant had a reasonable expectation that the information would remain private and or confidential and respective of subparagraphs 1 to 4.4. It is admitted that neither the claimant nor Miss X consented to the publication. However, neither the claimant nor Miss X took any steps to keep their relationship confidential. It is further admitted that the information came from a source, but the information from the source was that the source had seen the claimant and Miss X conducting their relationship in public. Even though the claimant is married with 2 children, he conducted his relationship with Miss X in public. Miss X and the claimant dined together in restaurants in London, where the claimant lived away from his wife during the week. The claimant also stayed over at Miss X's house and allowed him to be seen in the street with Miss X and the child. It is admitted that some of the information related to the child. The claimant made no efforts to protect the confidentiality or privacy of the child. For the reasons set out above, it is denied that the defendant misused the information. If, which is denied, the claimant had a reasonable expectation of privacy, there was a public interest in revealing the information. In support of its case, the defendant will the following facts and matters. The claimant is a well-known politician. The claimant has allowed himself to be seen having a relationship with a single mother wife. Paragraph 4 above and subparagraph 4.3 above is repeated. The claimant published an article in the Daily News 5 years ago headlined, "Why Families Should Stay Together." He set out his opposition to changes in the divorce laws and commented that the country would be a better place if marriages did not fail and families did not break up. The claimant made a speech in Parliament 2 years ago in the course of a debate about family values, in which he said it would be better for society if children were brought up by both their parents. In the circumstances, the defendant was entitled to correct the impression given out to the public by the claimant that he was a happily married man and a politician who spoke about family values which he did not adhere to in his own life. If, which is denied, the claimant has been distressed and embarrassed, it is denied that the defendant is liable for any damage caused. It is denied for the reasons set out above that the claimant is entitled to an injunction. The defendants believe that the facts stated in this defense are true.